Okay. Welcome, everybody, to Trademark Law and Free Speech, hosted by Northeastern University's Center for Law, Information, and Creativity. I am Professor Alex Roberts. I'm the faculty director of CLIC, and it is my great pleasure to host my friend and mentor, Professor Lisa Ramsey, today. Professor Ramsey is a professor at the University of San Diego School of Law, where she teaches trademark and intellectual property and other related classes, and she's been there for more than 20 years doing that. She has won numerous awards for her excellence in teaching and scholarship, and she is a prolific and a passionate scholar in topics across trademark and IP law, but in particular at the intersection of trademark and speech, making her absolutely the perfect person to write this book. So the book, which I have right here, I'm lucky to have my copy, Trademarks and Free Speech, Conflicts and Resolutions, was just published a week and a half ago on January 22. So I personally consider it quite a coup that CLIC has the privilege of hosting the very first book talk celebrating publication. You can buy the book on Amazon, Walmart, Barnes& Noble, on the Cambridge University Press website. And if you are a Northeastern student or faculty or staff, you can access the electronic version directly through our library network for free. So, and I think that Dean Hewer posted a link in the chat. If you need any help finding the link, you can email me or Craig Eastland at the library for the link. So, legal scholars who write books, I think, will typically tell you they're a labor of love or just a lot of labor, but they don't really expect a wide readership necessarily. So the fact that Professor Ramsey's book sold out immediately upon release is just such a crazy accomplishment, and I think a testament to what a great book this is. And we had about 60 people register, so I know that you're all really excited too, and I want to thank you for joining us. I'm going to turn it over to Professor Ramsey. She will present for about half an hour, and then we'll move into Q&A. And you're welcome to raise your hand at that time or type questions into the chat at any time. And I will kind of alternate and call on people when we're ready to do that. So Professor Ramsey, take it away.
Thank you very much, Professor Roberts, for that kind introduction. And thanks to all of you for joining me today. I have been working on this book for a number of years and started, I think, in 2018. And I've been writing about trademarks and free speech since 2004. So I care a lot about this issue, and I'm glad that Supreme Court in 2017 actually acknowledged that the free speech right in the First Amendment applies to trademark law, and that courts should take it into account when they are evaluating trademark registration laws and also application of trademark enforcement laws. So my book is not just focused on United States law. I also talk about laws in the European Union, in Australia, New Zealand, Singapore. But for my talk today, I'm going to focus on United States law. Because I have 30 minutes, but I am very excited to talk to you about this, and I look forward to your questions. So as I mentioned before, in 2017, we have Simon Tam, who applies to register the slants as a trademark, and the Supreme Court in a case that went that involved a law that banned registration of disparaging terms was struck down on the ground that it discriminated based on viewpoint. And after that case in Iancu versus Brunetti, the court struck down a law that banned registration of scandalous and immoral matter on the ground that it discriminated based on viewpoint. We've had other cases before the Supreme Court the last couple of years. It's one of the reasons why it took me a while to finish this book, but I'm glad that I waited, right? We have the Jack Daniels case where VIP Products puts out a parody dog toy, and the court has to struggle with how trademark enforcement laws should be balanced against the right to freedom of expression. And then we have Stephen Elster trying to register Trump Too Small as a trademark for T-shirts. And the court in that case acknowledging that trademark laws regulate speech based on its content, but that doesn't mean that they are actually inconsistent with the free speech right. So today I'm going to talk a little bit about the main themes in my book and how I make proposals for reform, not just in the United States and Europe. And I'm not telling governments what to do. What I'm trying to do is provide options and provide an overview of the kinds of laws that are out there in both the trademark registration and trademark enforcement context. And my hope in the book is to provide a framework for thinking about these issues when they arise. So I mentioned before, right, Eric Brunetti, he had applied to register FUCT. He claimed it was a acronym for Friends You Can't Trust, but everyone kind of figured out he's just trying to register the word fucked. And after he won at the Supreme Court, he decided to apply to register just the word fuck, F-U-C-K. And you'll see here on the screen the various words that he's tried to register over the years. Some of them have been registered and some of them are still pending. After the Supreme Court cases of Tam and Brunetti, you had a number of people try to register swear words, hate speech, and other kinds of language that had been previously refused registration under the disparagement, scandalous immoral mark provisions. And the USPTO started to refuse to register these kinds of marks on failure to function grounds. Now you'll see up here I have a screenshot of a certain article Alex Roberts wrote, which is amazing. I highly recommend you read it if you haven't read it yet, Trademark Failure to Function, where she talked about the fact that there's this doctrine at the USPTO that it applies that's a little bit different than distinctiveness doctrine. And so she urged scholars, courts, everyone to kind of pay more attention to trademark failure to function doctrine. I wrote a response to her paper and said, wow, this is a great doctrine. It actually helps the government actually protect freedom of expression, fair competition, by refusing to register terms that should arguably remain in the public domain. So you see in cases such as with Brunetti, with Snowflake Enterprises tried to register some hate speech, right, symbols of hate like a swastika. They argue they have a free speech right to register certain kinds of marks. In the book, I argue that actually this approach can harm freedom of expression, because once you have a trademark registration, you can invoke that to suppress other people's speech. You can do this through cease and desist letters or through filing a complaint with an online marketplace and getting those products, the t-shirts, other kinds of progressive merchandise taken down, or filing a lawsuit. And, big companies can afford to litigate, but small businesses, individuals might not, and so might self-censor. And so throughout the book, I talk about why we need to pay more attention to the fact that certain kinds of words, symbols, devices, names have inherent communicative value before they're claimed as trademarks. And I argue that swear words are one of those things. Not everybody thinks that swear words are valuable, but for one reason or another, a lot of people like to wear shirts that have swear words on them, jewelry, use other products that have these kinds of words on them. So in the book, I don't take the position that we shouldn't register swear words, but what I say is that governments need to think about the inherent communicative value of language or symbols claimed as trademarks, and think about, if we register these marks, is this actually going to further important trademark goals? And so some folks have argued that failure to function doctrine might conflict with the First Amendment, and I argue that it not only does it not conflict with the First Amendment, it actually furthers free speech goals. And so I'll talk about that in a little bit. And just real quick, though, back to the failure to function issue, the Federal Circuit in one of Brunetti's cases recently has asked the Trademark Office to try to clarify failure to function doctrine, because there have been inconsistent decisions and the standards are not clear. So in the book, I do actually try to take on this task of clarifying failure to function doctrine. And to be honest, it's kind of similar to my concept of inherently valuable expression, which I will talk about later. Another case that's been in the news, right, for a while, right, we have the Jack Daniels versus VIP Products case. The Supreme Court in that case a couple of years ago said that if you're claiming trademark rights in a phrase or a design, you can't take advantage of a speech protective test called the Rogers test, which typically in the past has been applied in the context of artistic and literary works with titles, right? Movies, books, etc. So the court, throughout the opinion, seems to acknowledge that the First Amendment limits the scope of trademark rights, but kind of narrows some of these doctrines in a way that I argue in the book are kind of not so protective of speech interests. And so now this case, it was back at the Arizona District Court, and the district court found that this parody, which poked fun at Jack Daniels, was not likely to cause confusion. And and then also, unfortunately, held that the particular image here, the poop jokes in this parody dog toy, tarnished Jack Daniel's brand. And this case now is at the Ninth Circuit. And one of the arguments that it may consider is whether trademark dilution law is consistent with the First Amendment. So again, how do we think about these issues, right? So in the book, I propose a framework for balancing trademark rights and the right to freedom of expression. Now, this framework is influenced by laws in the United States and other countries, Europe, where courts, governments struggle with these kinds of issues. And my framework is primarily targeted at legislatures, but I also encourage courts, trademark offices to take into account these issues when they're interpreting language of a statute. So first, we want to think about what are the purposes of this specific trademark law, and are they sufficiently important? So this is not the general purposes of trademark law, right? If we're talking about this specific provision, what are its goals? And in the book, I argued that there are three primary purposes of trademark law that I think most people would agree are goals we should aim to achieve. So first, preventing misleading uses of marks. Number two, promoting fair competition. And number three, helping the public identify and distinguish the source of goods and services. So there are other goals of trademark laws. For example, the law banning registration of someone else's name or image without consent, right? That protects the rights of privacy, right, of publicity, of people who have these names or images that would be recognizable, and who might want to prevent others from benefiting from their identity. So in the book, I say, look, we need to be thinking about what's the purpose of this specific trademark law. In the Elster case, the Supreme Court talked about the fact that one of the goals of trademark law is helping people identify the source of goods and services. I think they may have also mentioned preventing misleading uses of marks, but the law at issue in the Trump Too Small case actually did not require use of the name to be confusing. And so what I'm arguing for in the book is that you can't just talk generally about the goals of trademark law. You need to identify what is the goal of this particular trademark law. And this is different than identifying a theory of trademark law, right? Reducing consumer search costs. It's different than thinking about what are the functions of a trademark and protecting those functions, right? Trademarks have many different functions. In Europe, they talk about the origin function, quality function, investment, communication, advertising functions. It's true that trademarks do all of these things. But again, here, number one is the normative questions. What should trademark laws do in a democratic society where we actually desire free competition, free and fair competition? So that's the first question. Second, you want to think about whether this trademark law directly and materially advances its important purposes. So what do I mean by that? Well, we want to think about is there a nexus, right, between the means and the ends, right, the law and the goal that it seeks to achieve. And is this actually significantly making a difference? And then finally, we have the question of whether this trademark law suppresses or chills protected expression no more than necessary. If we're talking about misleading commercial speech or fraudulent speech, that's not protected by the First Amendment. Misleading commercial speech is also not protected in foreign countries. Hate speech is protected in the United States, not in other countries. So if the law is targeting unprotected expression, that's likely to be a conflict, right? But if this is non-misleading speech, if this is non-commercial speech, we need to think about whether or not this important purpose of the law is actually furthered, right, and harms expression too much. So we have people that like trademark dilution laws saying that, well, maybe we should protect property rights in trademarks or investment in the goodwill and reputation in circumstances where there is no likelihood of confusion, the parties are not competitors, and there's no proof of actual harm. And so in the book, I talk about the fact that trademark dilution laws discriminate based on viewpoint, right? Basically, they're saying that if your message is inconsistent, then the government can regulate it, even if it's not confusing, and even if it hasn't harmed the mark's ability to identify the source of goods and services. So with regard to trademark dilution law, you are basically stifling speech across industries because dilution laws can apply to any goods and services. So that's why trademark dilution laws are very problematic. And compare that to a law that bans registration of someone else's name or of a swear word or of hate speech. If you ban registration of something, that doesn't mean you can't use it. And so those kinds of laws are actually not as bad from a free speech perspective. In the book, though, I argue that actually registering words, symbols, devices, names that have substantial inherent value, that is very problematic because once you have a registration, it chills the speech of competitors and members of the public that might want to use that language in a certain way. So one of the main things I talk about in the book is subject matter with what I call substantial inherent value. Right, it has pre-existing informational, expressive, or decorative value that's unrelated to the party claiming trademark rights. So you look at the time where they decided to adopt this mark. Maybe they filed a intent to use application. Maybe they started using it in commerce. And look at before that. Was this a popular phrase, right? A trending phrase? Did something happen in the news and now everyone's trying to register it? Most recently, the Dunroe Doctrine was one people were talking about. So what I argue in the book is that either we should refuse to register inherently valuable expression as a mark when there's substantial inherent value, or only protect a narrow scope of trademark rights. So we should perhaps require the marks and the products to be identical or almost identical, require the defendant to be using this phrase, this symbol, as a trademark and not otherwise than as a mark. And finally, basically said, look, we have a higher standard for infringement. Maybe we require this to be a false statement by the accused infringer, or this use has to be likely to mislead about the source of the goods, services, or the message. As I mentioned before, I talk about trademark dilution law, discriminating based on viewpoint and stifling too much non-misleading expression. So this is something that I hope legislatures will think about. But if not, maybe we get the courts to do it. Perhaps the Ninth Circuit will strike down trademark dilution law, the tarnishment provision in the Jack Daniels case. In the Tam case, the court said that if you're targeting offensive expression, that's viewpoint discrimination. And trademark tarnishment laws actually are targeting opt-in uses of marks in connection with sex, drugs, other kinds of excrement that are offensive to people. But again, I actually argue in the book that trademark dilution by blurring law is also inconsistent with the free speech right. In the book, I also argue that we need more defensive doctrines in trademark statutes. And so I go through in chapters 4 and 5. Chapter 4 talks about the different kinds of trademark registration laws that protect speech interests, right? The requirement of distinctiveness. In many nations, they do not allow registration of functional matter. That's the registration context. In the enforcement context, I talk about the fact that some nations require commercial use of the mark, some require trademark use of the mark. Australia and New Zealand are examples. And I talk about statutory and common law defenses. In the last chapter of the book, I basically kind of provide the options for nations if they want to better protect free expression in the law. So in addition to not registering marks with substantial inherent value, I argue that nations might want to consider having a commercial use requirement or a trademark use requirement for liability, or perhaps a statutory defense for non-commercial use of a mark otherwise than as a designation of source. I talk about a test proposed by Christine Farley and I that is our proposed trademark fair use test. And then I also provide examples of the kinds of laws that governments can enact to protect informational fair uses, expressive fair uses, and decorative fair uses of marks. And I try to distinguish the cases where we might want to protect a merchandising right for universities or sports teams, but in other situations where we don't want to protect someone's exclusive right to put "let us turn up the beat" on the front of a shirt. Phrases like "let us turn up the beat" have substantial inherent value. Same thing for political slogans, trending phrases. So In the book, I try to work through these issues and provide options for governments. Again, my suggestions are aimed at legislatures, but I argue that if legislators don't act to better protect speech interests, that I hope that courts will consider these kinds of arguments. And in the United States, a lot of our law is judge-made law. So I'm hopeful. Finally, I've mentioned before, right, I'm hoping that courts and trademark offices will interpret statutes in a speech protective manner, but also in a manner that promotes fair competition. So if we're talking about the trademark office and failure to function doctrine, the question would be, right, should you register this common phrase as a mark? Well, I think already the office is looking at the content of the mark. What are the goods and services? And are people currently using the mark in an ornamental or expressive spot on products, or are they using it more on hang tags and labels? So I think it's great that the USPTO is applying failure to function doctrine in this way. And I think that my hope is that courts will take into account whether or not expression has substantial inherent value when they're deciding cases. And I have some additional examples for you on that. So I have a whole chapter 6, that talks about my concept of inherently valuable expression in trademark law. And again, this is matter with pre-existing informational, expressive, or decorative value in an industry or community before it was claimed as a mark. And how do you figure out if something has inherent value? Well, you look at the content of the mark. What's the phrase? Is it Nike? Is it a trending slogan like Black Lives Matter, a social movement? Is it a political message? And then you look at what are the goods and services. So I argue in the book that if we're talking about expressive merchandise, right, T-shirts, tote bags, the kinds of things you might find at a tourist shop, we might not want to grant trademark rights in those contexts because it prevents competitors from displaying or chills the speech of competitors who might want to display these phrases on the outside surface of products, increases prices if there's no competition in those markets. And consumers often want some of these products because of the words themselves, not because of the reputation of the trademark owner. And then finally, I look at, so you look at content, the goods and services, and where and the location or likely location of use of the mark. And so here are some examples of subject matter with substantial inherent value that I talk about in the book. So first, generic, descriptive, and informational terms and symbols. In chapter 1, I kind of do a deep dive into DC and Marvel's joint claim to trademark rights in superheroes for comic books, entertainment services, in the form of animated cartoons, T-shirts, toys. They recently actually kind of let their trademark registrations in the US for many of these products lapse. And so they're abandoned, but they still have a registration for superheroes, for animated cartoons that feature superheroes. Also, there's a company that claims trademark rights in UFO for a magazine and for entertainment services and sued J.J. Abrams' company when they put out a 4-part documentary series about UFOs. Now, they could defend themselves, but my concern is for small businesses and individuals who may not be able to do that. Cocky is a registered trademark, or was a registered trademark for romance novels, and people took down titles of their books. And Amazon took down titles of books that had this word in it. Authors changed their titles after they received cease and desist letters. So in the book, I also talk about popular colors and color combinations that had value before they were adopted as trademarks. One example, right, the colors of the United States flag or of other flags might be useful around the time of holidays, right? Independence Day, for example. Creative works and words and names associated with them. So my examples here are Uncle Sam, a German company, tried to register this image of Uncle Sam pointing at you, join the U.S. Army, in connection with products like that you might have at a picnic or something to that effect. It was refused registration on failure to function grounds, which I think is the right result. There was in it a French company that registered an illustration of the Mona Lisa for sausages and got a registration in the U.S. That is no longer active, but Martinson Flaben has some great work on why we might not want to protect trademark rights in culturally significant images. And I would argue, and I think that my approach in the book offers support for that argument and how you can actually what kind of doctrines can be used to not register these kinds of marks. I talk about the name or likeness of historical figures, leaders, and celebrities. Jesus is registered as a mark for genes. There are a number of universities named after important historical figures. I'm not saying that all of these marks should not be registered. What I'm saying is that for some of these marks, perhaps we protect them. Maybe they have secondary meaning, right? They've been used for a long time, but we only grant narrow rights. And again, I mentioned before what I mean by that, but I'll talk about that after I go through these examples. I talk about words and designs of value to indigenous communities, right? Cherokee is registered as a mark for clothing, for cars. Kokopelli is the god of fertility. And when I traveled around Arizona, see a lot of hotels that use this image or the name Kokopelli. And, some people might say that only the indigenous community should own rights, right? There are some challenges. I talk in the book about, well, if you grant some people rights, then still there might be young people who might want to use the words or symbols in different ways. But one argument is if anyone's going to own rights, it should be the people in the community. But perhaps no one should because these kinds of things should not be registered as trademarks and should remain in the public domain for use by all unless other laws apply. I talk about political messages, right? Slogans for social movements, make America great again. That term was used by Reagan and Bush before Trump decided to use it and register it as a trademark for not just political action committee services, but for expressive merchandise like hats and T-shirts. We have slogans for social movements like Black Lives Matter is an example, and I would argue that anyone should be able to put these kinds of phrases on the front of a T-shirt. Trending phrases and memes a while back, people were trying to register "Okay, Boomer." This is no longer hip, but every month it seems that there's some new phrase that's hot and people try to register it as a mark for T-shirts or other kinds of expressive merchandise. You all see this with puns and jokes. So "Let us turn up the beat" is an example. Positive and uplifting sentiments, right? "I love you" is someone tried to register that for jewelry that looks like you see here. Holidays, right? Christmas, Dia de los Muertos. These kinds of phrases should arguably remain in the public domain, or if they are registered, the rights should be narrow. Communicative symbols like hand gestures. In the book, chapter 4, I talk about Gene Simmons' application to register this devil's horns hand gesture as a mark for his entertainment services. And apparently they're going to have a virtual Kiss rock band play in Vegas at some point. So I talk about, in the context of trademark registration laws about what are the things you want to be thinking about, right? Distinctiveness, functionality, etc. Common words and symbols displayed on T-shirts and other kinds of expressive merchandise. It's something I spent a lot of time on in the book. Swear words, I Heart New York, that's registered as a trademark. I Heart DC was refused registration on failure to function grounds. And one of the things that I talk about in the book when I talk about reforms of failure to function law is that currently, if a mark has been registered for 5 years, you can't challenge it on lack of distinctiveness or failure to function grounds. Also, this is not a defense if the registrant's right to use the mark has become incontestable, subject to certain limitations. So that's one of the reforms I have in proposed reforms in the book. I also think we should separate out, for those of you trademark geeks like me, informational matter and expressive matter in the failure to function regulations because it's all together in one section. But I agree with the Federal Circuit that we need to clarify failure to function doctrine. I spend a lot of time talking about the lifeguard mark and the Greek cross symbol. There's a company that has a registration for that phrase, that symbol, and has enforced it against companies big and small. And then everybody versus racism, again, an example of a common sentiment that has been registered, or someone tried to register and refused registration under failure to function doctrine. And then finally, popular designs and shapes. So Crystal Head Vodka is a brand of vodka. Dan Aykroyd and his buddy jointly own, he's one of the co-owners of Crystal Head Vodka. And the bottle shape is based on crystal skulls found in the Yucatan. And I'm fine with them having rights, but I think they should be narrow. They decided to enforce their rights against a couple selling bloody hell hot sauce, and so you can see the images there. So overall, I'm hoping that trademark offices, courts will take into account whether expression has inherent value, and if it has substantial inherent value, right? We want to have a narrow scope of rights, right? Perhaps we require the parties' marks and products to be identical or almost identical. We say that the accused infringer should use the trademark as a designation of source for its own goods or services. And or, right, that it used the mark in a false statement about its own products. Maybe it falsely claims the goods are licensed when they're not, or this use is likely to mislead a reasonable person about the source of the goods, services, or message. So here's an example. When I was a kid, I liked the Choose Your Own Adventure books. That's a trademark for a series of books where about people who are having adventures, right? And you can actually choose where the story leads. When Daimler Chrysler had decided to put out an advertisement for the Jeep Patriot a number of years ago, it had a tagline, "Choose Your Adventure." And the book company was claiming that they were trying to free ride off of nostalgia for the Choose Your Own Adventure brand. So again, I have no problem with Choose Your Own Adventure as a registered trademark at this point. It's a very famous brand, but I think they should not be able to enforce it against parties selling different products. Ultimately, the case settled, but these kinds of lawsuits should not be brought. Same thing, like I mentioned with Crystal Head Vodka, you get rights in alcoholic beverages, not for other kinds of products. And then just recently in the news, right, you have a doctrine of foreign equivalence case with people claiming rights to merci, right? French for chocolate, French for thank you for chocolate, and then danke for chocolate. And even though when you translate both words, they're thank you, and those are identical, these words have substantial inherent value when you're talking about chocolate, something that you might give someone to thank them. So, again, my hope is that my proposals in the book will be useful to governments, not just in the United States and other countries. But at this point, I'm going to open it up for questions.
Fabulous. Thank you so much. I imagine it's really hard to distill years of work in an entire book into a 30-minute talk. So you did a great job. I'm going to kick it off with a couple of questions. So I know you took an international and comparative approach in researching and writing the book, and you mentioned that you were going to do a more focused presentation. I think the United States kind of prides itself on taking speech protections very seriously, more seriously than other countries. Do you find that to be true when it comes to trademark law? Or would you say that some other countries' trademark systems actually do a better job of holding space for free speech, ensuring mark owners aren't able to use trademark law to censor or limit speech, things like that?
That's a great question. So in Europe, in the EU trademark regulation and EU trademark directive, in the preamble part of those laws, it says that courts should interpret the trademark laws in a manner that protects the fundamental human rights and says specifically freedom of expression. So you actually have the legislature recognizing we need to take free speech interests into account. And in the US, you see this in the legislative history for the trademark dilution laws, which were regulating, right, non-misleading expression. And Congress was very clear, like, look, we're putting in these exemptions to protect speech interests. But here you have in the statute itself saying that courts should take it into account. And so in the Constantine film case, where someone tried to register the English equivalent of fuck you, goth or something, the court said, okay, we're going to take this into account. But ultimately it found this law that banned registration of immoral marks or marks against public policy that had been invoked to refuse registration, or it doesn't actually end up applying a free speech analysis to strike it down or anything. What it says is that we're going to clarify the rules about what's immoral and against public policy. And so basically now allows them to kind of go back and register this kind of phrase. So I think that, and then we've seen some other decisions at the EU IPO, right, where you have people trying to register covidiot, and then also some words that are kind of like hate speech or against people who are homosexual. Although there was a party trying to reclaim the term, like Simon Tam, and there they really are acknowledging that if you have a registration that or at least, well, what they're saying is that if you can't get a registration, you can still use the mark. And I didn't see that in the Tam and Bernetti decisions, and it was quite frustrating. Well, Bernetti, some of the justices pointed out that he could still use it. So I do like it that the EU IPO is kind of taking this into account. The Advocate General in the Constantine film case, who's like a judge that kind of helps the court decide what it might do, had noted that we need to take into account the free speech interests of the public, right, and competitors, not just the free speech interests of the party trying to obtain trademark rights. And you see in, I think, the Maricon Fertitta case that the EU IPO also cites that. And then for Australia and New Zealand, I think their requirement of a trademark use of the mark for liability is very speech protective. There are some pros and cons of this kind of requirement. In Europe, you have commercial use of the mark required for infringement liability. In the US, we don't have that requirement. But I actually think that's okay, because if a political organization uses another's mark in a confusing way, this can cause serious harm, right, if they're using it as a trademark. So I guess my take is that a lot of nations are protecting speech interests in different ways. And that's why I don't have a one size fits all kind of solution here. I just say, look, here are all the options. This is what these countries are doing. Some have good statutory defenses, like Australia has a comparative advertising defense in its statute. And so my hope is that Congress, right, the United States might consider maybe we add more language. And Bill McJevran has a great article, the Trademark Fair Use Reform Act, where he proposes changes to the statute. And so my hope is, and I talk about his work actually at length in the book. So I'm just hopeful that nations can learn from each other in this context.
Well, that would be ideal, wouldn't it? Probably something that we in particular can work on. How good or bad, or maybe how inconsistent or consistent would you say that the USPTO Trademark Office is at making these nuanced judgment calls? So, I think my failure to function paper and really several of my papers, my conclusion has been like, the law is good and the law addresses this and we don't need to change it. We just need to actually consistently apply it, right? So, is the thrust of your argument more that we need to change the law or that we need to apply the law we have or something else? Thinking about some of these great examples you mentioned, UFO, Cocky, Black Lives Matter, is enforcement a greater threat to speech than protection and registration on the front end?
Lots of good points there. So first of all, I think that we do have a lot of excellent laws on the book, both on the trademark registration side and the trademark enforcement side. But I also agree with you. There's a lot of inconsistency, and this is one of the things the Supreme Court pointed out in Tam and Bernetti is that you had some marks were registered, some were not. You have the same word, right? The F word. So it'd be helpful if trademark offices paid more attention to these kinds of issues. And my understanding is that examiners are being trained. I'm hopeful that they might be trained even more on how to recognize the fact that they might want to consider the impact of registering a particular kind of common phrase, widely used phrase, or decorative product feature, how that might impact competition and free speech. Because once you have that registration, it can be invoked on Amazon or on these online marketplaces, and they're not going to be doing some sort of judicial-like interpretation of whether a fair use defense applies, et cetera. So that's one reason why I think it's so important to, rather than rely on defensive doctrines and courts doing the right thing, we need to not allow a lot of these marks to be registered in the United States. But of course, if they're registered in another country, that can still be a problem. So I think that we have some common law doctrines that judges are that are just all over the map. And so the benefit of changing the statute to have like the trademark fair use defense that Christine Farley and I mentioned is to provide a little bit of clarity on there and consistency, because to be honest, all trademark laws are pretty vague. Bill McJevran talks about this, right? The likelihood of confusion standard, nominative fair use. A lot of these doctrines, you can't always predict what the result is. And from a free speech perspective, we want certainty, we want predictability. We don't want litigation to be very expensive, because then small businesses, individuals, right, can't afford to litigate to a successful result. And so that's why I agree with Bill McJevran and others who argue that we need to make changes to the statute itself. to protect speech interests. And, obviously you want to have the correct result, but you also want to make it easier to dismiss a case on a motion to dismiss. And luckily, in the Jack Daniels case, the Supreme Court said that you can grant a motion to dismiss if the parties' marks are dissimilar or certain contexts make it unlikely that there will be confusion.
Great. I think this is a related question. So you propose a test that you just shared with us that would guide courts in protecting only a narrow scope of rights in expression with substantial inherent value. So I want to ask, is it feasible? Is this idea of narrow rights or weak protection, thin protection, a real thing or a legal fiction? Because I think, there has been some scholarship kind of arguing like, well, that's nice in theory, right? But it's not going to carry through because the USPTO could say, okay, we give this narrow, thin protection. But then when it comes to courts enforcing down the line, they're going to basically say it's either registered or it's not. It's either protectable or it's not. And if it is, they're going to go ahead and treat those rights as pretty robust. So is this, do you think, a workable solution or kind of an ideal that would be hard to meet?
So first of all, I think a lot of courts are already doing this. So they're using something similar to my framework, right, and similar to this approach. So here's some examples. In the Jack Daniels case, Elster, a lot of these cases, you see the Supreme Court talking about the goals of trademark law, whether this law furthers those goals, and then the court says, oh, and it's not going to harm free expression, right, because this is a source confusing use of the mark, or other comments like that. So I think first of all, I think some courts are already doing this, and I'm not. Well, I didn't say this yet in the talk, but I say this in the book. I'm not recommending we have constitutional analysis in every case. All I'm asking is that courts take into account these issues as they're formulating their opinions and really think about not just does the law further the goals, but also what's the effect on free speech. And I think if you do that with regard to trademark dilution law, it's more likely the court might find for the defendant or ultimately, hold the law unconstitutional. With regard to the narrow scope of rights, here's an example. I'd mentioned we talked about the Donkey and Merci marks for chocolate. So in that case, the TTAB, if you translate the terms, they both say thank you, right? So the marks and products are identical. And you have use as a trademark in that context. But here, no one's going to be confused, right, about use of these terms, right, because it's not going to mislead a reasonable person about the source of the goods and services. Why is that? Well, you look at, the fact that it's inherently valuable expression, right, that chocolate's often used as a gift, right, to thank somebody for something. So I think you can take this into account in various ways. And when you're figuring out the strength of the mark, right, that's one of the things that the TTAB did in this case involving the thank you litigation. I just say, look, this mark's not as strong, even though thank you arguably has nothing to do with chocolate, right? Some people would say, it's arbitrary. Lifeguard has nothing to do with t-shirts, right? Some would say it's arbitrary. Same thing with superheroes. But in the end, if you think about the right of competitors to put these phrases on t-shirts and for the public to buy them at an affordable cost, my hope is that courts will protect narrow rights if these kinds of marks are protected.
That's a great and optimistic answer. And also now I want chocolate. This is something that you touched on. I wanted to see if I can get you to talk a little bit more about it. So in the book, you point to trademark protection of certain kinds of phrases, generic, descriptive, political messages, trending slogans as both harmful to speech and anti-competitive. So what do you view as the relationship between speech and competition? Are these kind of like, two separate pillars, two important values that are both relevant to trademark law, two different reasons to push back on granting exclusive rights to marks that have substantial inherent value? Or are speech and competition tied together in some way?
Yeah, no, that's a great question. In some contexts, it's more about competition than free speech. So functionality doctrine in the United States, if we're talking about utilitarian functionality, a dual screen design that keeps road signs upright, that's not really going to implicate free expression interests. Once the patent expires on that device, arguably anyone should be able to use it. And it's anti-competitive to hinder the ability of competitors to use that device in the marketplace. If we're talking about aesthetic functionality doctrine, though, here it can be anti-competitive and harm free speech interests, right? Because if you have a phrase like "let us turn up the beat," or a decorative feature that had inherent value before it was claimed as a trademark, it's anti-competitive, right, to grant a single company exclusive rights to that expression or that decorative feature. And it also harms the ability of competitors to use it in connection with their sale of products. We know commercial speech is protected by the First Amendment, not just non-commercial speech. And if it's not misleading, right, arguably it's Congress and the government, right, they have to prove that they have a strong government interest in regulating the speech, a compelling government interest if it's non-commercial speech. So rather than talk about like, well, maybe colors, does anyone have a free speech right to use a color? I guess I want to flip it around and say, why does the government have the right to grant one company exclusive right to a certain color, a certain phrase in connection with expressive merchandise? So I think and then I also in the book talk about the fact that one of the goals of trademark law is promoting fair competition, right? Sometimes people talk about that in reverse, right? Preventing unfair competition. But there are a lot of provisions in the statute. I think it's better to frame it as promoting fair competition. The ban on registration of merely descriptive words without secondary meaning, or a ban on registration of generic terms, the ban on registration of functional matter, even if it has acquired secondary meaning. And again, I think failure to function doctrine does a great job furthering both free speech interest and competition interest. So I think for litigants, I would argue, make both arguments. Why not, right? But the free speech argument is not really going to work out when you're talking about utilitarian functionality doctrine.
Yeah, I love that framing as promoting fair competition, not just preventing unfair competition. That's wonderful. I'm going to share a question from Lorraine Fleck in the chat, and she says, great talk. She would be interested in your views on the relationship between free speech and government restrictions on trademark use that some call brand restrictions. So, for example, plain packaging, banning the use of mascots or cartoon characters on packaged foods and alcohol, mandatory packaging requirements that limit the real estate available for trademark display, restrictions on trademark use in advertising, like limiting ads to children, and advertising certain products only after 9 p.m., banning alcohol and cigarette companies from sponsoring events, municipalities refusing to allow ads from certain companies on municipal property, restrictions on gambling ads, all that stuff.
Yeah, no, great question. So first of all, that's not something I talk about in the book, but I'll still give you my thoughts on it. So here we have the government, these are commercial speech regulations, right? And so you'd have the Central Hudson analysis would apply in that context. And I agree, some of these regulations are problematic. Again, I don't address it in the book. But I guess one thing I'd like you to think about is if, one of the arguments you could make, for example, for registering superheroes as a trademark, right? DC and Marvel were primarily preventing registration of superheroes for various products. People tried to register superheroes for beer, right? For an adult-oriented comic called Superhero Happy Hour, right? So you could argue, well, maybe we don't want the phrase superhero to be used in the context of goods and services targeted at adults. They might attract children. So what I argue in the book is that regardless of whether you think that is a compelling or substantial important government interest in making sure kids aren't exposed to adult products, it's not a primary goal of trademark law. We need to think about what are the goals of trademark law, and those kinds of interests, which might be important to some people, but not others, are not something we need to be taking into account in the context of trademark law. Plain packaging legislation, I know you've seen this in Australia, where they force really graphic images of like cancerous lungs on packaging. I personally don't like seeing that. I understand what they're trying to do, but I guess my take would be to have less regulation of advertising by the government. And, again, commercial speech is protected by the First Amendment if it's not misleading.
Yeah, those are extremely graphic, but I guess if you don't want to see them, then don't handle boxes of cigarettes. Okay.
Well, they're on buses too. It's not just on cigarettes.
Oh, I didn't know that.
And so it's everywhere. Yes.
That's intense. A question in the chat from Doris Long. So Professor Long says, I love the idea of the special rules for expressive products. Would you remove those expressive items as a category for federal registration, or simply require that phrases be used as trademarks, like on hang tags, as a company name, etc.?
Yeah, no, again, another great question. So clearly Nike functions as a mark for shoes, but also shirts, right? And so So I think that we still should allow registrations. It's class 25, right, for t-shirts, hats, etc. But when it comes to inherently valuable expression, like I have up here on the slide, my hope is that the USPTO will use failure to function doctrine, genericness doctrine, merely descriptive without secondary meaning doctrine. I mean, one way you could frame it is if this phrase is likely to be displayed on the product itself, you could say that this is a generic or descriptive term for that particular product. And that was an argument made in one of the cases involving the lifeguard mark. This company that had put lifeguard on the front of shirts basically said, look, lifeguards wear shirts that have lifeguard on them. It's not serving as a source identifying mark for t-shirts. And so I think if the PTO is focused more on whether this phrase is identifying a single source of goods and services, whereas I think Nike would, we're going to be fine. But the problem is that often PTOs focus on whether consumers associate a phrase with the trademark or owner or applicant. So an example is Lizzo recently was able to register 100% That Bitch. This was a lyric in one of her songs. She actually hadn't come up with that phrase. Another musical artist had posted a meme or something. I posted about this and it became a meme. And so I argue in the book that just because you have an association doesn't mean it's actually serving as a source identifying trademark. And so if you look at the definition of a trademark on the statute, you can tie it to that and say, look, we're not going to register common phrases like this or even like invented phrases if competitors are likely to want to put those phrases on the front of a shirt. People might want to put Nike on the front of a shirt, but they want to do that because of the brand reputation. And so that's same thing with university logos, sports team logos. People are buying those because they want that connection to the brand. And so I distinguish that from someone wanting to buy a shirt that, has one of these different kinds of, things on it, like a trending phrase or a political joke, or even the Statue of Liberty, right? If you're traveling, you might want to buy souvenirs. And so to me, there's just a difference. And so I propose a decorative fair use defense or aesthetic functionality can be applied in that context. And you see judges, I think, have gotten it right. You have the automotive gold case where people were trying to use the VW Audi logos on license plate frames and argue that this was an aesthetically functional use. Well, people wanted those products because of the reputation of the trademark owner. Compare that to the Let Us Turn Up the Beat case, where the Ninth Circuit, in an unpublished opinion, did apply aesthetic functionality doctrine because people wanted the shirts that said "Let us turn up the beat" because of the phrases themselves and not because of the reputation of the brand owner. So I guess that's how I would deal with these cases: is that apply aesthetic functionality doctrine now, or perhaps have Congress adopt a decorative fair use doctrine that really kind of distinguishes between these kinds of uses.
We have about 5 minutes. I don't see any hands, but I want to make sure I'm not missing anyone. Okay. So you have so many great examples in the book, obviously. I mean, you really did your homework, and there are a ton of great ways to come at this idea. I'm just wondering, like, when you're giving the elevator talk or the cocktail party summary of the book, have you found that there is any best example to highlight how trademarks and speech rights intersect that people really respond to?
Yeah, no, that's again a great question. So I mean, I think that people claiming trademark rights and Black Lives Matter is an example, right? When they applied to register with an individual that I don't think had any connection to the organization, so some organizations that were trying to coordinate the social movement applied to register it, they put the phrase Black Lives Matter on the label, on the hang tag, and they said, "Oh, look, we're using it as a trademark." But it's very clear it also had Black Lives Matter on the front of the shirt. And so I like it that the USPTO has said that just because you happen to put it in the trademark spots, right, or spaces that you submit in specimens of use, that's not going to be enough if this is clearly a widely used phrase or other kind of phrase that fails to function as a trademark. So I think that's one example. Right now, I mean, it seems like every week there are great examples. Some folks in Europe that I know were posting about the George Orwell case, where the EU IPO refused to register George Orwell, right, the author of 1984, or I guess the pseudonym of the author of 1984, as a mark for products in the, I think, publishing and entertainment industries, right? And again, the argument for leaving that in the public domain is so that anyone can use that phrase. Some countries do not have a trademark use requirement for liability or a commercial use requirement for liability. And so once a name like George Orwell is registered, right, it can be used to chill the expression of others. I think let's see, other examples. I think the cocky trademark dispute is a really interesting one. The fact that you have self-censorship and private censorship. And when the case actually gets to court, the trademark owner or registrant's like, oh, wait, yeah, I'm actually going to settle this case because cocky is not a strong trademark for romance novels about cocky men. I think Eric Goldman has talked about the company who registered the term emoji for lots of different goods and services, and then went on Amazon and used its rights in emoji to actually take down products that just in the product description described what was on the product as an emoji. So you might have coffee mugs, right, or T-shirts that have emojis on them, and Amazon took it down. And so again, for those of you who might think, well, look, trademark enforcement doctrines can take care of this, narrow scope of rights or defenses. That's the problem, is that we have this self-censorship, this private censorship by online marketplaces and possibly robots, right, rather than humans deciding whether to take it down. And so I really do think we need to stop registering inherently valuable expression. But again, I know that this is going to be difficult for a lot of folks because they have an investment in here. Here's another example. Right now, the Supreme Court is trying to decide whether a case involving Rebecca Curtin's challenge to Rapunzel for dolls. And so for those of you that don't know, right, these dolls are Rapunzel dolls. And the issue at the Supreme Court is whether she has standing to challenge this registration as a consumer. But one of the interesting things to consider is whether anyone should own exclusive rights to Rapunzel for dolls. And of course, they could sell dolls that don't look like Rapunzel. And again, I don't know if there's actually an official what Rapunzel looks like. Obviously it was a written story from long ago. But again, from a free speech, from a competition perspective, my hope is that, people will think about, well, wait a second, why are we registering these kinds of terms? And again, if we're trying to prevent misleading uses of marks, well, if we don't register them in the first place and anyone can use them, then people won't be confused. They'll know there are certain words or symbols or colors that anyone can use. And you might have a film titles that are similar, or book titles that are similar, right? Some people might say, oh, only one company should own rights to that particular title. No, right? People should be able to talk about, use certain phrases and titles, and you can look to other information to find out who the source of the film or the book is, right? The name of the author or the folks who directed it or the production company, et cetera. So, I think we need to treat consumers as sophisticated enough to be able to figure out who the source of the product is and not grant exclusive rights to companies or celebrities that can establish that the public associates certain words or symbols just with them.
Yeah, and I think you highlighted such an important point in there, which is that it's not just about registration and enforcement in courts, right? Enforcement happens in the shadow of the law. It happens with cease and desist letters, private enforcement, and then also platforms like Amazon doing their own kind of censoring and editing. So the kind of trickle down effects of the formal registration are so tremendous, and very often outside what we can control when we revise the doctrines that the courts are actually using. Lisa, thank you so much. This has been educational and fascinating. And I'm seeing post chats in the messages in the chat that people are just really excited to get their hands on the book again because it sold out so quickly. I think they're going to push out more books, and once everyone gets those, they'll be really busy reading. So thank you so much for joining us today. And congratulations.
Thank you for inviting me, and thanks to anyone who's interested in the book. And feel free to reach out if you have any additional questions. I can answer by email. But as you can tell, I love talking about this topic. And if you're in San Diego, we're having an in-person book event on February 23rd. So if you go to my website, Lisa P. Ramsey, there's information about all the different talks, the Trademark and Free Speech book, part of my website. But again, I appreciate your feedback. Thank you.
Me too.